Okay, full screen. Today is October 12th, 8:16 p.m. Recording. Chapter 8, Cruise 2024, the Philippine Constitution. Chapter 8, the Legislative Department. The new constitution has revived the Congress of the Philippines, which was replaced during the Marcos regime with the Batasang Pambansa. The name of that legislature is tainted and disgraced, which is probably one reason why it was not retained to designate the new legislature. The old Congress under the Commonwealth Constitution, for all its rather questionable record, was never a rubber stamp of the president, at least not in the servile way the Batasang Pambansa was to Marcos. The adoption of the former name of the lawmaking body will resurrect memories of freer days when the Congress was a peer of the other two departments and in some respects even more powerful than either of them. The new Congress represents a return to bicameralism after our recent experiment with unicameralism, which was established by the 1973 Constitution, and in fact, also initially provided for in the 1935 Constitution before it was amended in 1940. The Malolos Congress was also unicameral, and so too was the TAP Commission during the early years of the American regime. The Philippine Bill of 1902, however, provided for a legislature consisting of a Philippine Assembly and the Philippine Commission, which under the Jones were replaced by the House of Representatives and the Senate, respectively. The Philippine legislature, as it was called, was the pattern of Congress of the Philippines that was organized under the 1940 constitutional amendments. Under the present rules, the Congress of the Philippines also consists of a Senate and a House of Representatives, although many important modifications have been introduced. One of these, Section 1 of Article 6, readily indicates it that the legislative power is not exclusively vested in the Congress in view of the reservation made regarding initiative and referendum. The said Section 1 provides the legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provision on initiative and referendum. The Congress also discharges powers of a non-legislative nature, among them being the canvass of presidential elections, the declaration of the existence of a state of war, the confirmation of amnesties, and through the commission of appointments, presidential appointments and amendments or revisions of the Constitution and impeachment. The Senate composition. Section 2 states that the Senate shall be composed of 24 senators who shall be elected at large by the qualified voters of the Philippines as may be provided by law. By providing for a membership elected at large by the entire electorate, this rule intends to make the Senate a training ground for national leaders and possibly a springboard to the presidency. The feeling is that the senator, having a national rather than only a district constituency, will have a broader outlook for the problems of the country instead of being restricted by parochial viewpoints and narrow interests. With such a perspective, the Senate is likely to be more circumspect and broad-minded than the House of Representatives. 2. Qualification. The qualification for membership in the Senate are laid down in Section 3 as follows. No person shall be a senator unless he is a natural born citizen of the Philippines and on the day of the election is at least 35 years of age, able to read and write, a registered voter, and a resident of the Philippines for not less than 2 years immediately preceding the day of the election. According to Article 4, Section 2 of the Constitution, natural born citizens are those who are citizens of the Philippines from birth without having to perform any act to acquire or perfect their Philippine citizenship. Those who elect the Philippine citizenship in accordance with paragraph 3, section 1 hereof shall be deemed natural born citizens. The age qualification is fixed at 35 and must be possessed on the day of the elections. That is, when the polls are opened and the votes are cast, and not on the day of the proclamation of the winners by the board of canvassers. This nullifies the ruling in the case of Espinosa versus Aquino, which upheld the late Senator Benigno Aquino Jr., who was less than the required age of the day of the election, but celebrated his 35th birth anniversary before his proclamation as one of the winners. Registration as a voter is also included as a qualification for this office. He can be registered anywhere in the country because senator is a national officer. The literacy requirement is now specifically prescribed because it is not deemed embraced in the suffrage qualification under the present constitution. Residence is defined as the place where one habitually resides, to which, when he is absent, he has the intention of returning. A person cannot have two residences at the same time. Acquisition of a new residence results in forfeiture of the old. However, an intention to abandon his old residence cannot legally be inferred from his act in establishing a home elsewhere or otherwise conducting his activities therein. In the absence of a clear showing that he has decided to adopt a new residence. Thus, a legislator who built a house and established a law practice in Manila but occasionally visited his relatives and his properties in his home province was deemed not to have forfeited his legal residence in the latter place. An individual does not lose his domicile even if he has lived and maintained residence in different places. Residence, it bears repeating, implies or factual relationship to a given place for various purposes. This nullifies the ruling in the case of Espinosa versus Aquino, which upheld the late Senator Benigno Aquino Jr., who was less than the required age on the day of the election but celebrated his 35th birth anniversary before his proclamation as one of the winners. Registration as a voter is also included as a qualification for this office. He can be registered anywhere in the country because a senator is a national officer. The literacy requirement is now specifically prescribed because it is not deemed embraced in the suffrage qualification under the present constitution. Residence is defined as the place where one habitually resides, into which, when he is absent, he has the intention of returning. A person cannot have two residences at the same time. Acquisition of a new residence results in forfeiture of the old. However, an intention to abandon his old residence cannot legally be inferred from his act in establishing a home elsewhere or otherwise conducting his activities therein. In the absence of a clear showing that he has decided to adopt a new residence, thus, a legislator who built a house and established a law practice in Manila but occasionally visited his relatives and his properties in his home province was deemed not to have forfeited his legal residence in the latter. An individual does not lose his domicile even if he has lived and maintained residences in different places. Residence, it bears the repeating, implies a factual relationship to a given place for various purposes. The absence from legal residence or domicile to pursue a profession, to study, or to do other things of a temporary or semi-permanent nature does not constitute loss of residence. It has accordingly been held that the term residence is to be understood not in its common acceptation, as referring to dwelling or habitation, but rather to domicile or legal residence that is the place where a party actually or constructively has his permanent home, where he, no matter where he may be found at any given time, eventually intends to return and remain animus manendi. Domicile, according to the Supreme Court, denotes a fixed permanent residence to which, whenever absent for business, pleasure, or some other reason, one intends to return. It is a question of intention and circumstances. In the consideration of circumstances, three rules must be borne in mind, namely, one, that a man must have residence or domicile somewhere. Two, when one established, it remains until a new one is acquired. And three, a man can have but one residence or domicile at a time. If one wishes to successfully effect the change of domicile, he must demonstrate an actual removal or an actual change of domicile, a bona fide intention of abandoning the former place of residence and establishing a new one, and definite acts which will correspond with the purpose. Without clear and positive proof of the concurrence of the three requirements, the domicile of origin continues. According to Paul Liamanzares versus Commission on Elections, there are three requisites to acquire a new domicile. One, residence or bodily presence in a new locality. Two, an intention to remain there. Three, an intention to abandon the old domicile. In other words, there must basically be animus manendi coupled with animus non revertendi. The purpose to remain in or at the domicile of choice must be for an indefinite period of time. The change of residence must be voluntary, and the residence at the place chosen for the new domicile must be actual. Applying the foregoing criteria, the Supreme Court disqualified on the ground of failure to comply with the residence requirement a candidate who sought to establish his residence with his voter registration records, a marriage certificate, water bills, and a deed of sale covering property in the place where he sought to be elected. In rejecting his evidence on his claimed residence, the Supreme Court noted that his alleged change of domicile was effective solely for the purpose of qualifying as a candidate in the 2007 election, stressing that establishing residence in a community merely to meet an election law requirement defeats the purpose of representation. To elect through the assent of voters those most cognizant and sensitive to the needs of the community. Indeed, the court has ruled that approval of voter registration does not presuppose 6-month residence in the place prior to registration. Excuse me. To be an actual and physical resident of a locality, one must have a dwelling place where one resides, no matter how modest and regardless of ownership. The mere purchase of a parcel of land does not make it one's residence. The fact that the residential structure where petitioner intends to reside was still under construction on the lot she purchased means that she has not yet established an actual and physical residence in the barangay. Moreover, a temporary stay in a stranger's house cannot amount to residence. In contrast, the court ruled in Halover versus De La Peña that the law does not require a person to be in his home 24 hours a day, like the law specifically tells you this. That the law does not require a person to be in his home 24 hours a day, 7 days a week to fulfill the residency requirement. The court explained in said case that the fact that Osmeña has no registered property under his name does not belie his actual residence in Toledo City because property ownership is not among the qualifications required of a candidate for local election. It is enough that he should live in the locality, even in a rented house or that of a friend or a relative, to use ownership of property in the district as the determinative indicium of permanence of domicile or residence implies that only the landed can establish compliance with the residency requirement. That makes sense. So it's like, does that mean that if you don't have a land, if you're just renting somewhere, living with someone, does that mean you're not a resident of that place? So that's why it's spelled out here in the Constitution. In Limbona versus Comelec, the court likewise declared that a candidate is presumed to have changed her domicile upon her marriage or by operation of law, consistent with the provision of Article 68 and 69 of the Family Code, to the effect that spouses shall have a single family domicile unless one of them maintains a separate residence. It will be recalled, though, that the ruling in the earlier case of Marcos versus Commission on Election was different. Thus, parenthetically, parenthetically, when petitioner was married to then Congressman Marcos in 1954, petitioner was obliged by virtue of Article 110 of the Civil Code to follow her husband's actual place of residence fixed by him. The problem here is that at that time, Mr. Marcos had several places of residence, among which were San Juan, Rizal, and Batac, Ilocos Norte. There is no showing which of these places Mr. Marcos did fix as his family residence, but assuming that Mr. Marcos had fixed any of these places as a conjugal residence, what petitioner gained upon marriage was actual residence. She did not lose her domicile or origin. Residence is, I suppose that's Congressman Emil, what you call this? Amy Marcos, I think. Oh, sorry, no, it's Mr. Marcos. But isn't it the assumption if a male gets married, then the woman goes with the male? This is assuming that Mr. Marcos had fixed any of these places as conjugal residence. What petitioner gained upon marriage was actual residence. She did not lose her domicile of origin. So it's the pronoun that confuses me. Anyway, residence is in any part of the Philippines, like in the case of the partyless representative member of the House of Representatives. And unlike in the case of district representative member of the House of Representatives who must reside in district where he is running. In Mitra versus Comelec, the Supreme Court explained that officials or districts of locality should not only be obtained with the metes and bounds. It's not right. Yeah. More importantly, they should know their constituencies in the unique circumstances. Putol dito. Their constituents, their needs, difficulties, aspirations, I'm guessing, potentials for growth and development and material vital to their common welfare, familiarity, the opportunity to be familiar with these circumstances can only come with residency in the constituency to be represented. The purpose of the residency requirement is best met by individuals who have either had actual residence in the area for a given period or who has been domiciled in the same area, either by origin or choice. At the same time, the constituents themselves can best know and evaluate the candidates' qualifications and fitness for office if these candidates have lived among them. The qualifications prescribed in the section, a continuing requirement, that is, they must be possessed for the entire duration of the member's incumbency. It has, of course, been consistently ruled by the Supreme Court that residence is distinct from citizenship. Thus, senators and members of the House of Representatives must be natural-born citizens not only at the time of their election, but during their entire tenure. Accordingly, if a legislator should, say, be naturalized in a foreign country during his term, he shall cease to be entitled to his seat. It is therefore uniformly provided under the rules of procedure of both House of Representatives, Electoral Tribunal, and the Senate Electoral Tribunal that a petition for quo warranto may be filed by any registered voter on the ground of ineligibility based on citizenship at any time during said member's tenure. A petition for quo warranto may also be filed at any time for grounds that occur during the term of office of the winning candidate. In Makiling versus Commission on Election, the Supreme Court declared that a candidate who takes his oath of allegiance to the Republic and executes the affidavit of renunciation of his American citizenship under the provision of the Republic Act number 9225, but thereafter continues using his American passport, is to be considered as having recanted his oath of renunciation of his foreign citizenship and shall therefore be ineligible to run the elective office as he thereby reverts to his status as a dual citizen. It has likewise been explained that a party list representative who is required to have been, among others, a bona fide member of his party or organization for at least 90 days preceding the day of the election must maintain his bona fide membership in his party list group during his incumbency because this is a continuing qualification. We have ruled that qualifications for public office, whether elective or not, are continuing requirements. They must be possessed not only at the time of appointment or election or as of assumption of office, but during the officer's entire tenure. They are also exclusive under the principle of expressio unius est exclusio alterius, with the result that it is not competent for Congress to provide by mere legislation for additional qualifications, no matter how relevant they may be. For example, a statutory requirement of a college degree as an added qualification for membership in the Congress would be unconstitutional. See, that's not, I think that we should set a little, the bar high for our leaders, but can't apply a law retroactively, so that's why. I wouldn't mind raising the bar for our public officials because, I mean, they are indeed running the country, so it's like we're selling ourselves short when we like accept candidates that are not qualified for the positions that they have. Not to say it's about judging people and stuff like that, but it's just about you're going to run the country. You're going to help run the country. You have a position, you have a location to handle. And if you are not properly or well educated for that position, then how can you actually run the position that you have? Okay. That's just my opinion. Accordingly, Section 36G of RA 9165, which required all candidates for public office, whether appointed or elected, both in the national or local government, to undergo a mandatory drug test. I am so positively supportive of that. Upon petition of, among others, the senator declared unconstitutional by the Supreme Court in Social Justice Society versus Dangerous Drugs Board for having infringed the constitutional provision defining the qualification and eligibility requirements for one's aspiring to run for and serve as senator. The court explained Section 36G of RA 9165 as sought to be implemented by the assailed Comelec resolution effectively enlarges the qualification requirements enumerated in Section 3, Article 6 of the Constitution as couched. Said Section 36G unmistakably requires a candidate for senator to be certified illegal drug clean. Obviously, as a precondition to the validity of a certificate of candidacy for senator or with like effect, a condition sine qua non to be voted upon and proper be proclaimed as senator elect. The Comelec resolution completes the chain with the. Did I skip a page? No. Okay. Comelec resolution completes the chain with the proviso that no person elected to any public office shall enter upon the duties of his office until he has undergone mandatory drug test. Viewed, therefore, in its proper context, Section 36G of RA 9165 and the implementing Comelec resolution add another qualification layer to what the 1987 Constitution at the minimum requires for membership in the Senate. Whether or not the drug-free bar set up under the challenge provision is to be hurdled before or after election is really no moment, as getting elected would be of little value if one cannot assume office for non-compliance with drug testing requirement. I think it should be done when you're applying for a position. If you're gonna run, you should have drug tests. I mean, that's just my something that something I'd like to look into maybe when I am blessed with what I am trying to do here eventually. Of course, this ruling would be applicable even to members of the House of Representatives and other elective and appointed constitutional officers. So it should. I mean, if you're a public official, before you apply to run, you should have a drug test. We wouldn't want an addict running for office. So if they win, we know that they are actually drug free. And then I think that all government officials, all government employees should have a mandatory drug testing that is random every 6 months because, right? I mean, they're going to run the country, so why not? What is there? What's the problem if we had that? It would be a problem for those that are using and those that are using and are in the position and can withdraw from it. That's a problem. But if you're clean and you have good intentions when you're an elected official, I don't see why we should have a problem about drug testing when we apply, before we file. It should be a requirement. I'm filing for this position, running for the election. I'm drug free. Here's my requirement. But it's not that easy because this is something that has to be done through legal means because it's going to change some of the requirements that will have to be satisfied by candidates that have plans of running for the election, if and when it becomes a law or part of the requirement of filing for candidacy, which I think it's about time we should have that requirement. Yeah. Okay. Of course, this ruling would be applicable even to the husband. I read that already. It should be stressed that a person intending to run for public office must not only possess the required qualification for the position for which he or she intends to run, the candidate must also possess none of the grounds for disqualification under law. And that an individual possesses the qualification for a public office does not imply that he is not disqualified from being a candidate or continuing as a candidate for a public office and vice versa. It has as well been held that the opportunity to run for public office is a privilege that may be subject to limitations as imposed by law. Term. The term of the members of the Senate is governed by the following provisions in Article 6 and Article 18, respectively, Section 4. The term of office of the senator shall be 6 years and shall commence, unless otherwise provided by the law, at noon on the 30th day of June, next following their election. Section 2, the senators, members of the House of Representatives, and the local official first elected under this Constitution shall serve until noon of June 30, 1992. Of the senators elected in the election in 1992, the first 12 obtaining the highest number of votes shall serve for 6 years and the remaining 12 for 3 years. The 24 senators first elected under this Constitution on the second Monday of May 1987 served a term of only 5 years ending on June 30, 1992. Of the 24 senators elected in 1992, the first 12 obtaining the highest number of votes served the full term of 6 years, expiring in 1998. And the last 12 served a term of only 3 years, ending in 1995. The 12 senators elected in 1995 served the full term of 6 years. Those elected in 1998 also served the full term of 6 years, as so too those elected in 2001. In other words, beginning 1995, 12 senators were elected every 3 years to serve the full term of 6 years. So that unlike the House of Representatives, walang vacuum. The Senate shall not at any time be completely dissolved. One half of the membership is retained as the other half is replaced or re-elected every 3 years. It is for this reason that the Senate has been described as a continuing institution, as it is not dissolved as an entity with each national election or change in the composition of its members. However, in the conduct of its day to day business, the Senate of each Congress acts separately and independently of the Senate of the Congress before it. Accordingly, all pending matters and proceedings, i.e., in past bills and even legislative investigations of the Senate of a particular Congress, are considered terminated upon the expiration of that Congress, and it is merely optional on the Senate of the succeeding Congress to take up each unfinished matters, not in the same status, but as if presented for the first time. This is consistent with the general characterizations of Congress as not a continuing body, particularly with respect to the passage of bills. Accordingly, in League of Cities of the Philippines versus Comelec, it was ruled that the unapproved cityhood bills filed during the 11th Congress became mere scraps of paper upon the adjournment of the 11th Congress. All the hearings and deliberations conducted during the 11th Congress on unapproved bills also become worthless upon the adjournment of the 11th Congress. Said deliberations on approved bills do not even qualify as extrinsic aids in construing laws passed by subsequent Congresses. It should be noted that, though that it has been ruled that the Senate's power to punish for contempt in the exercise of its power to conduct inquiries in aid of legislation does not cease to exist upon the periodical dissolution of Congress or of the House of Representatives, because the Senate is for said purposes or in connection with said power to be considered a continuing body, according to the Supreme Court in Arnold versus Nazarino. That Arnold was in the Senate, asked questions about a check he received to the sum of 40,000, I believe it was. And then he was asked who gave him the check. He wouldn't say because he said that he didn't want to expose himself to criminal liabilities. And then he was put in contempt of court until the Senate could get the answer that they wanted from him. And then he, Arnold, filed a case in the Supreme Court. He wanted a habeas corpus, or he wanted to be heard, due process, why he didn't want to divulge the information that the Senate wanted because of criminal liabilities. And the judicial court, Supreme Court, says, well, the legislative body is an investigative body to create laws that are based on their investigation. So it is their rightful duty and responsibility to get the truth in whichever way they think they can. And if they have to contempt somebody, then it is what it is, that they weren't going to meddle. So basically, the judicial body, the Supreme Court, said, we leave that decision for the Senate to make. So all of the people invited in hearings in both houses know that if you get a contempt of court during fact-finding committee hearing, yan na, diyan ka talaga hanggang sinabi nilang, okay, pwede ka nang umalis. So, that's it. Now I understand why there was literally nothing even VP Sara could do when they detained her chief of staff, attorney, I forgot what her name was, Lopez. Couldn't do anything, couldn't get her out because of this landmark case where if you have been found in contempt of court during a hearing, especially in the Senate and even in Congress, then there's no getting out of that until the House gets what they want. Okay. To hold that it may punish the witness for contempt only during the session in which investigation was begun would be to recognize the right of the Senate to perform its function, but at the same time to deny it an essential and appropriate means of its performance. Aside from this, if we should hold that the power to punish for contempt terminates upon the adjournment of the session, the Senate would have resumed the investigation at the next and succeeding sessions and repeat the contempt proceeding against the witness until the investigation is completed. An absurd, unnecessary, and vexatious procedure which should be avoided. The foregoing notwithstanding, it has since been held by the court that the period of imprisonment under the inherent power of contempt by the Senate during inquiries in aid of legislation should only last until the termination of legislative inquiry under which the said power is invoked. It stated that once the said legislative inquiry concludes, the exercise of the inherent power of contempt ceases, and there is no more genuine necessity to penalize the detained witness, and pointing out that a legislative inquiry ends upon the approval or disapproval of the committee report and the expiration of one Congress. It is significant that in Garciliano versus House of Representatives, the Supreme Court, citing the separate opinion of Mr. Justice Carpio Ineri versus Senate Committee on Accountability of Public Officers and Investigations, stressed that the present Senate under 1987 Constitution is no longer a continuing legislative body. The present Senate has 24 members, 12 of whom are elected every 3 years for a term of 6 years each. Thus, the term of 12 senators expires for every 3 years, leaving less than a majority of senators to continue into the next Congress. The 1987 Constitution, like the 1935 Constitution, requires a majority of Senates to constitute a quorum to do business. Makes sense, right? Applying, because if you have a 24 and you have 12 for re-election every 3 years, then you don't really have a majority. What you have is a break even, 12-12. Applying the same reasoning in Arnault versus Nazarino, the Senate under the 1987, because this happened in 1935, this case, this Arnault and Nazarino, somewhere before the 1987 Constitution. Senate under 1987 Constitution is not a continuing body because less than a majority of the Senate continue into the next Congress. The continuity of the life of the Senate is intended to encourage the maintenance of Senate policies as well as guarantee that there will be experienced members who can help and train newcomers in the discharge of their duties. It should be noted, however, that as desirable as experience may be, the Constitution specifically provides in Article 6, Section 4, that no senator shall serve for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. The Constitution seems to be wary of elected officials who stay too long in the office, probably because they may entrench themselves in power to the exclusion of other aspirants for their office, and perhaps also create or maintain the political dynasties. Oh gosh. Let's not even go there. There is political dynasties, and it's not even defined actually. Wala tayong balaod against it because hindi na kailangan expelling yun. Nobody would probably even support it. It would be left out on the floor because a lot would be apektuhan, di ba? I'm talking to myself. Okay. Other aspirants for their office and perhaps also create or maintain the political dynasties discouraged and screwed in Article 2 as a matter of state policy. The senator can serve no more than 12 consecutive years. The term of the members of the Congress of the Philippines under the old Constitution began on the 30th day of December. Next, following their election in November, inasmuch as the election date has been moved to May, it has become necessary also to change the date for the commencement of the term of the members of the Congress. It is curious, though, that it has been set on the 30th day of June, considering that this is the end of the month, and unlike Rizal Day, does not have any historical significance. Furthermore, there does not seem to be any reason for making the term start at exactly noon, as in the case of the President of the Philippines. His term commences at noon because of the ceremonies held in connection with his formal inauguration, but the legislators do not have to wait for that long to begin their own term. Perhaps might have been better to provide that the term of the office of the members of Congress shall commence on the first day of July, and without waiting for high noon. This may yet be done now by ordinary legislation. True enough. Agree. Hold on a second. Kailangan po